One of the director's general duties is to promote the success of the company, and that means putting the interests of the company and its shareholders first. But if there's significant financial difficulties, the rules change. Directors must do what they can to look after the interests of the creditors. Whatever they do or don't do, it should be with the aim of getting the best possible result for the creditors. Only when they've secured them their money, if they can, do they start working for the shareholders again.
Can you tell us exactly when they should start doing that?
Well, it might be easier to see in hindsight, but this is what the Insolvency Act says.
Knew, or ought to have concluded, that there was no reasonable prospect that the company would avoid going into insolvent liquidation. The key phrase is knew or ought to have concluded.
What exactly should we do if we think we might be getting close to that point?
You should almost certainly seek proper advice.
Start with your accountant or solicitor, and if they're not suitably qualified, they should put you in touch with someone who is. You might need to talk to a licensed insolvency practitioner. Needless to say, this talk would be on a confidential basis.
The decisions are yours, but if you don't act on the advice, you'd better have a good reason.
You might be advised to carry on, but be careful and make changes. You might be advised to put the company into administration. You might be advised to stop trading. You might be given other advice. And of course, there are several other possibilities.
It's dangerous to carry on trading beyond the point at which trading should stop. To coin a phrase, if you're in a hole, stop digging. If trading goes on too long and further losses are made, there's a risk that they might be down to the directors personally. I'm sure you'll agree that that's a terrible idea.
What personal risks might we run in this situation?
These are the three main ones: prosecution and possible disqualification, wrongful trading, and fraudulent trading. There are a range of criminal offences that directors can commit. Examples are falsifying accounts, hiding assets, and not cooperating with a liquidator or administrator. The punishment is usually a fine, and directors can be disqualified as well. Disqualification is to protect the public. It's not a punishment, though disqualified directors often see it as such.
I've already mentioned wrongful trading. It happens when a company carries on trading after the point that trading should stop. An action can only be brought when the company goes into insolvent liquidation, and if it succeeds, then the directors must contribute to the deficiency.
How often does that happen?
Not all that often, and not as often as the creditors would wish. The problem from the creditors' point of view are the legal costs, the uncertainty, and the fact that there's no point in suing the directors if they haven't got the money to pay.
The final risk is an action for fraudulent trading. This is worse than wrongful trading because it involves dishonesty. Placing orders that you know will not be paid is an example. An action can only be brought if the company goes into insolvent liquidation, and the directors can be made to pay a sum to the liquidator for the creditors.
Are all directors treated the same? Do they always sink or swim together?
No, that would be most unfair because the degree of fault can vary, and some directors might not even be at fault at all. Having dealt with these core topics, let's move on a couple of months and listen into a board meeting of Approved Software Limited and see how they're doing.
It's 10 o'clock, so I declare the board meeting open. Rachel will be taking today's minutes. No apologies, I see. Everyone's present who should be. I'll start by thanking everyone for getting the necessary papers around 3 days before the meeting. It really helped, so well done. Item 1 on the agenda, minutes of the last meeting. You've all seen them. Any questions?
Can I just clarify, when will we be receiving the product development schedule? The minutes state that you were aiming for the end of this week?
Yes, that's right. I'll be circulating an updated document after the meeting.
Thanks, James. Right, can I take it that everyone's happy? Great, thank you. I'll sign them off.
Excellent. A perfect start.
Item 2, approval of the accounts and the director's report. We have to do that with a formal vote and minute the decision. Are we all in favour?
Aye.
Thank you. I'll sign the balance sheet later, and Diana, you can sign the director's report.
Okay.
Still doing well. Let's move on a few minutes.
We've given the budget a really thorough review this morning. Comments?
I can't see anything that needs changing.
In which case, I propose that we adopt the budget as it stands. Is everyone happy?
Yes?
Great. Unanimous. 4 votes to none. It may not be easy, but I'm convinced that with the sales and marketing plan that we've got, we really can achieve that turnover and profit.
Oh dear, I've just seen a bad mistake. Diana's not a director, but she voted and her vote was counted. Do you remember what I said about de facto directors? Let's move on a few minutes.
The next item on the agenda is the authorisation of a director's conflict of interest. You've all seen James's letter, and you'll know that he wants to become a non-executive director of Tring Taxicabs Limited. Now, they're one of our customers. This is the first time that it's happened to us, so I want to do it strictly by the book. Diana, could you take it through step by step, please?
Well, first of all, the board can only authorise a conflict of interest if the articles or a shareholders' resolution allows it. Now, we got the articles changed last month, so that's not a problem. Now, secondly, James can't count towards a quorum or vote, and neither can any other director with an interest. Well, there is no other director with an interest, so we needn't worry about that. And I've checked the articles, and a quorum is 2, so that's not a problem either. And finally, the board should do what they believe is in the company's interests. You should believe it is in the company's interests, or at least not against the company's interests.
I see no problem whatsoever. Tring Taxicabs is only a small customer and it might be good for our business. And it will keep James happy, which might be good for our business as well. So I vote in favour.
My view exactly. That's both of us. The board authorises James to accept the appointment.
Thank you. Much appreciated. Thank you very much.
Didn't they do well? Excellent.
There is just one further item of business. Diana, you've done a first-class job for us. Now, I've talked it over with Jenna and James, and we'd like you to join the board right away, rather than wait until the end of the year. Oh, do the articles allow the directors to make the decision, or do we have to put it to the shareholders?
No, that's one thing I don't have to look up in the articles. The directors can make the decision. Thank you. I'm delighted to accept, and I'll make sure the form goes off for Companies House well within the 14 days.
Excellent.
Congratulations.
Thank
On
you.
that note, I declare the meeting closed.